But Nicolai, I think especially as it relates to this conversation specifically, and one that comes up all the time for people, is the ability to concurrently file one's adjustment status, because this is not an opportunity that was always in place for the EB-5 program. Going back to the origins of the program, this is not something that was available. This is something that came along with the passage of the Reform and Integrity Act in 2022. So maybe if you'd like to talk a little bit about that and that opportunity, especially as it relates to Crystal's prior points about H-1B holders and doctors and other professionals.
Yeah, absolutely. So you're right. It was not a possibility to concurrently file before the passage of the EB-5 Reform and Integrity Act, which was passed in March of 2022. We call it the RIA. So the RIA made a number of significant changes to the EB-5 program. As I mentioned earlier, the program's been around since 1993. It's been extraordinarily popular and successful, but Congress wanted to make some changes and some improvements to the program, really take it to the next level, if you will. And they did that, I think, by passage of the RIA. One of the key changes they made there was to permit now, for the first time in the EB-5 program, concurrent filing. And what does that mean? It means that along with the initial EB-5 immigrant petition that you file, which is filed on a form called an I-526E, if an individual is in lawful non-immigrant status in the United States, like H-1B or like an F student, for example, they can, if a visa is immediately available for them. So if they are not from a country that has retrogression in any of the EB-5 set-aside categories, and right now all of those categories are current, there are visas available. So if those two things are true, then along with the I-526E, they can file an adjustment of status form. That's filed in a form called an I-485. And it's asking the government to adjust a person's status from non-immigrant to immigrant, right, to become a green card holder. Now, of course, the I-485 cannot be approved until the I-526 is approved. And the I-485 is its own form. It's used across many different immigration categories, family-based and employment-based. So it has its own processing time, kind of independent from I-526E. Many people think that, you file the I-526E, and as soon as it's approved, my I-485 will be approved. It doesn't work that way. But it is a prerequisite for approval that the I-526E has been approved. But the government gives you two very key benefits while you are waiting in the United States for approval of your 485 or issuance of your green card. And that is temporary work and travel authorization. So along with the I-485, you can file an I-765, which is going to give you work authorization pursuant to an EB-5-based EAD card. Also, you file an I-131, which is going to give you the right to travel in and out of the United States on something called advanced parole. Sometimes these two benefits are issued on the same card, and we call that a combo card. It's really just a matter of convenience, having both of those rights evidenced on a single card. More often these days, we're seeing USCIS first approve the EAD, because that's typically what people want the soonest. And then second, we see the advanced parole being approved. But so what this grants somebody, the benefit that, say, an H-1B holder would derive from this is an independent right, separate from the H-1B status, to remain in the United States and work in the United States. So if there was, for example, a layoff, if an H-1B holder didn't have a pending I-485, they would have to leave or find another employer. And you referenced earlier, Pete, people often call with questions about EB-5, and there's real urgency, right? It's sort of an emergency situation. But with an EB-5 concurrent filing, they have a kind of fallback, right? We advise all our clients that if possible, we want them to maintain that H status if they can until they get the green card. because that hedges any potential issue that might arise with a 485 or the I-526. This is very important, and I think more important today than it's ever been. It's very nice to have that to fall back on, if possible. Sometimes it's not possible. Sometimes there's a layoff and, but then somebody has that ability to stay in the U.S. that they wouldn't otherwise have. Right. So it is an independent way to stay in the U.S. and that is tremendously powerful and attractive for many H-1B holders. I get calls almost every day for people who are worried about layoffs or want to be entrepreneurial and go and open their own business, or just really want to have that hedge in view of many of the things that Crystal talked about. That's extraordinarily stressful just from a human psychological perspective, to have the specter of these changes hanging over you. And if you can have in your back pocket a fallback position that would allow you to stay here in the United States, you have U.S. citizen kids or whatever your specific circumstances are, not only is that powerful as an alternative immigration strategy, but psychologically it's I think extraordinarily beneficial for an individual. So concurrent filing really is something that has drastically changed the EB-5 landscape. Before the passage of the RIA, it was only possible to file an I-485 after I-526 approval. But after the passage of the RIA, now a significant percentage of our clients are people that are coming to us directly in the United States, filing EB-5 in the United States rather than outside the United States. And that speaks to the benefit that a petitioner derives from concurrent filing.